Okay, now we start the video. Good morning, Miss Prima. My name is Ko Su-Yuan from Batch 4A. Student ID is 2290014 BLE. Here I want to share about the introduction about white-collar crime. White-collar crime is an illegal or is fraudulent act, a non-violent crime where the primary motive is typically financial in nature. White-collar crime usually occupy a professional position of power and one that commands well above average compensation. According to Coroner 2011, white-collar crime range from thief at work to fraud and corruption. White-collar crime can be done on both a local and global level, often targeting people from outside of the offender country, making it harder for prosecution. As worker companies have a duty of care towards both their workforce and the consumer. However, this is not always enforced and can often result in financial loss and loss of life. Introduction about insider trading. Insider trading involves people buying and selling shares in their own company. It is illegal? Yes. The answer is it depends. Both legal and illegal insider trading exists. When it is illegal, it is a serious offense. People found guilty of illegal insider trading can end up in prison for a long time. For example, illegal insider trading. Let's imagine that you work for ABC Pharmaceutical. The company chief scientist tells you that the best-selling drug may have some dangerous side effects. He tells you that the company will make a public announcement today. Nobody else knows about this. If you sell your share secretly before the announcement, you are guilty of illegal insider trading. For the element of the insider trading, have four types. I type here. First, the defendant actually received information. This means the individual accused of insider trading must have obtained information about a company. This information could come from various sources, such as company executives, employees, or other insiders. Second, the information was material. Material information is any information that could influence an investor decision to buy or sell securities. It typically includes data recording a company's financial performance, upcoming mergers or acquisition, regulatory decision, or other significant events that could impact the stock price. The information was not public is the third element. Insider trading involves trading based on information that has not been disclosed to the general public. If the information is widely available to the public, it's not considered insider trading. Non-public information is often referred to as inside information or material non-public information, MNPI. The fourth element is the information directly influences the defendant trade. The insider have use the non-public material information to make a trade in the company's security. This means the information play a significant role in their decision-making process regarding buying or selling stock. And without this information, they might not have made the same trade. Now I want to explanation on case study. Case 1, Jesman V. Directorate of Market Abuse. The matter of Jesman and another V. Directorate of Market Abuse and another 2001 6 involved applied to the High Court against a finding of the FSB and is one of a very few reported judgments in South Africa dealing with insider trading. Although in this matter, the charge of insider trading were both under the Securities Service Act 36 of 2004 SSA, which have since been repealed by the Financial Market Act 19 of 2012. This judgment remains relevant as the definition of insider information and the offense of insider trading are identical in both acts. For the case 2, Martha Stewart. Martha Stewart is one of the few businessmen who can still claim widespread popularity after a highly publicized scandal. She is the founder and former CEO of Martha Stewart Living Media, a company with interest in publishing, television, merchandising, electronic commerce, and related international partnership. In the early 2000th century, America's most famous homemaker became the center of headline speculation and eventually a federal investigation concerning her stock trading. Martha Stewart was accused of insider trading after she sold 4,000 Imclone shares 1 day before that firm's stock price plummeted. Although the charge of security fraud were thrown out, Ms. Stewart was found guilty of 4 counts of obstruction of justice and lying to investigators. She was sentenced to 5 months of prison, 5 months of house arrest, and 2 years of probation. Fact of the case 1. The pertinent facts in this matter were that Mr. Jesman and his company, Harrison and White Investment Appearance, embarked on a strategy of acquiring a controlling interest in Africa Circular Towers Limited (LISCO), a company listed on the alternative exchange of the JSE. A due diligent investigation and evaluation of the business and of LISCO were undertaken, during the course of which the appellants came into possession of information that LISCO has secured a loan from the Industry Development Corporation to the amount of 99 million, subject to the finalization of the agreement relating to such loan. Relevant information. Certain LISCO shares were acquired by the appellants at the time when it was public knowledge. After the shares were acquired by the appellants, the details of the loan were announced on SENS and the share price of LISCO share increased dramatically. face of the Martha Stewart to uphold federal security law and safeguard investors. The Security and Exchange Commission (SEC) was created, investigating possible securities fraud and filing charges against individuals found guilty of participating in illegal activity are some of its main objectives. The SEC charged Martha Stewart and her former stockbroker Peter Bakanovic with security fraud on June 4, 2003, stating that they had engaged in illegal insider trading when they sold shares in the biopharmaceutical company Omicron System after receiving an inside information tips from Bakanovic by selling her Omicron stock after obtaining the insider tip. Stewart allegedly prevented losses of $45 and $637 according to the SEC lawsuit, which was submitted in federal court in Manhattan. The comparison of the case is legal jurisdiction for the Zessman case. One potential difference could be the legal jurisdiction where each case took place. Martha Stewart case occurred in the United States. Okay. Miss, I think I put the wrong place. Okay, never mind. These are here have the 1, 2, 3, 3 comparison of the case, but I just read out. Individual involved. Martha Stewart is a well-known public figure and businesswoman who may have influenced the public perception and media coverage of her case. For the Zessman case, the individual involved in Zessman with Directorate of Market Abuse may be less widely recognized, potentially affecting the level of attention and scrutiny surrounding the case. For the judgment and conclusion of the case, Case 1, after reviewing the law on insider trading in Europe and the United Kingdom, rejected the appliant contention and held that a circumstance or event need but not in a final form in order for the information relating to such circumstance or event to qualify as specific and precise. For the Case 2, Judicial Commissioner Tun Mohammad Amin Wan Yahya heard the case and determined that an has violated Section 188(2)(a) of the 2007 Capital Market and Service Act. Okay. And in my own way, I need to say in the case of the Zessman with Directorate of Market Abuse, it likely that is pertained to a legal matter in South Africa involving allegation of market abuse. abuse, which could include insider trading among other offenses. Unfortunately, I don't have specific details on this case. The Martha Stewart case, on the other hand, is a well-known insider trading case in the United States. Stewart, a prominent businesswoman and TV personality, was convicted in 2004 for conspiracy, obstruction of justice, and making false statements related to herself of I'm cloned. In my opinion, the Zesman v. Directorate of Market Abuse case is important of thorough diligence. Contacting through the diligence before engaging in any market activity is crucial. For the Martha Stewart, for the ethical conduct, insider trading undermines the integrity of financial market and breaches trust between investors and companies. Both individuals and corporations should uphold ethical standards and avoid trading on non-public information. For the conclusion, based on Case 1, the penalty of $1 million that was imposed by the FSB was informed by the potential profit the appellants could have made from the insider trading, and the court found there was no basis to set aside that penalty. Based on Case 2, clearly instead of insider trading has not died down since the Martha Stewart scandal. However, Stewart's conviction did demonstrate that high-profile individuals would not be immune from the penalties of misconduct. Even successful CEOs of Fortune 500 companies are being forced to account for questionable behavior, as evidenced by Mark Hart's resignation from Hewlett-Packard after an internal probe indicated sexual harassment. Thank you.